Good morning and welcome to the 15th meeting in 2025 of the Delegated Powers and Law Reform Committee. I'd like to remind everyone to please switch off or put to silent the mobile phones and other electronic devices. Just want to make everyone aware that Katie Clark will be leaving throughout the meeting this morning because Katie's putting forward some amendments to a bill which stage 2 process is taking place at the moment. And Jeremy Balfour is currently in that committee pressing some amendments, so he will be joining the committee in due course. The first item of business is to decide whether to take items 7 and 8 in private. Is the committee content to take these items in private? Yes. Under agenda item number 2, we're considering an instrument subject to the affirmative procedure. No points have been raised on the draft Town and Country Planning Marine Fish Farming Scotland Amendment Order 2025. Is the committee content with this instrument? Yes. Under agenda item number 3, we're considering instruments subject to the negative procedure. No points have been raised on SSIs 2025, 112, 124, 125 and 126. Is the committee content with these instruments? Yes. Under agenda item number 4, we are considering instruments not subject to any parliamentary procedure. No points have been raised on SSIs 2025, 106, 115 and 119. Is the committee content with these instruments? Yes. In relation to SSI 2025-106, does the committee wish to highlight to the Standards, Procedures and Public Appointments Committee its correspondence with the Scottish Government regarding the policy note? Yes. Under agenda item number 5, we are considering a document subject to parliamentary control. No points have been raised on SPSO 2025-01. Is the committee content with this document? Yes. In relation to this document, does the committee wish to highlight to the Local Government, Housing and Planning Committee its correspondence with the Ombudsman? Yes. Okay. Under agenda item number 6, we are taking further evidence on the leases, automatic continuation, etc. Scotland Bill. And before we begin taking evidence on the bill, I want to put on the record that all members of the committee rent office premises in our capacity as members of the Scottish Parliament. Now, while this does not represent a declarable interest in the bill, we wanted to put this on record, given that the subject matter of the bill concerns commercial leases. For our first panel today, I'd like to welcome Dr Jonathan Brown, lecturer in Scots Private Law at the University of Strathclyde, and also Dr Mitchell Skilling, teaching fellow at the University of Aberdeen. Welcome to you both. Before we start, can I remind you not to worry about turning on the microphones, that they'll be undertaken for you. And if you do want to come in on a question, just please raise your hand or indicate to the clerks. And there's also no need to answer every question if you don't want to deal with that. But certainly, after the committee, if there is something that you feel you hadn't said on the record that you would like to put in the record, you can please feel free to do so in writing afterwards. So we'll move to the questions, and certainly the first question is, do you think that the law on tacit relocation needs reforming, and if so, what are the main problems currently?
Thank you very much for inviting me. Thank you, Mitch, for passing over to me first. So, in effect, the view that I would probably have here is that there isn't absolutely a pressing need for reform, and indeed some of the recommendations, particularly in terms of the change of language used, are actually slightly harmful rather than helpful. And I'll be able to get into exactly why that is. But I think one thing that is quite clear, given that we're dealing principally here with commercial leases, is that there are interests and imbalances involved that are not necessarily like other leases, where, you know, if it's a residential situation, then saying that the residential tenant is ipso facto in a weaker position than the landlord seems like it's generally quite a straightforward thing to say. When one is dealing with a commercial lease, though, just because one party is the landlord does not mean axiomatically that they will be in a stronger position than the tenant. And so it's worth bearing in mind that where commercial leases are concerned, and as with any lease broadly, we're dealing with a contract that is between two parties. And so in terms of that contract, representing the interests of one as opposed to the other in general as being, you know, one party stronger than the other isn't quite correct here. And so I think that this sort of area is one in which freedom of contract is extremely important. It's an area in which the law that is built up around tacit relocation really is quite well understood. Some of the points about it being unclear and the like just don't strike me as correct. If anything, rather than the law being unclear, it seems more that the law is flexible because it is uncodified. And that means that there is a lot of latitude for the parties to any agreement before we even get into the realm of what the courts would make of those agreements. There's a lot of room for the parties to any agreement of lease to make their own reality, so to speak. And the law of tacit relocation does that, and does that quite well. So in terms of that, I don't necessarily think that reform is something that is absolutely necessary. And in terms of the point of language, which is the last thing I'll say before I pass over, there have been a number of representations made that the change of language from tacit relocation to automatic continuation, the change of language concerning ish to date of termination and so on, are useful. I don't think that that is in fact the case, because when you're dealing with terms of art, such as we are here, changing the language does not come easily. Changing the language to be automatic continuation rather than tacit relocation, if anything, just complicates matters, because it means that someone who comes across this statute is likely to think that they know what it's talking about and form their own view on that without necessarily having the full understanding of what the background is. And where tacit relocation is concerned, you come across the phrase tacit relocation, you know immediately, you don't know what that means. So what do? You look it up. There's an impetus for that. And if you do look up tacit relocation, immediately you get a whole host of articles which are concerned principally with this subject as we understand it. You know that the material that you're using is good law in this jurisdiction because it's talking about a concept expressed in a language that we use in this jurisdiction. And so to change the terminology to something else just means that from a teaching perspective, but also from a practical perspective, one is going to then just have to say, well, automatic continuation, what does that mean? Well, it means tacit relocation, which means this. You're just adding an additional layer onto that. And you see that very often when terms of art are changed in any jurisdiction you care to name. Geschäftsordnung Auftrag in Germany, for instance, is explained in any commentary on the German basic law as, oh, this is just the Roman institution of negotiatum gestio. And as to a final point in terms of the word ish, a number of respondents have said, yes, progressing to the use of plain English is something to be lauded. But I think that this is actually something that is in direct conflict with the Scottish Parliament's own commitment to the Scots language, because the word ish, although most familiar in the context of Scots law and the Scots law of leases, is in fact just an ordinary word of the Scots language. It means a means to egress, a means to exit. And so while, you know, one might say, yes, expressing a statute in plain English is quite useful, the Scots language, as this Parliament recognises, is only spoken within Scotland. It's not really used anywhere else. And although it's been recognised as an essential element of the culture and heritage of Scotland, familiar from our songs, poetry, literature and so on, the Scots language is an essential part of our law. And it is one of those aspects where the Scots language continues to be not only alive, but thriving in the sense that it is still used to describe these essential concepts. So in terms of this, in summation, I think some of the points around language which are being introduced by this new bill are actually more problematic than has hitherto been understood. In terms of the overall approach of reforming this area, if the suggestion is that this area needs to be reformed because the law is not clear, I think I'm afraid I have to reject that outright. The law is quite clear, quite well understood. If people from other jurisdictions who are coming to Scotland have an issue with understanding what the particular Scots law is, that can be rectified quite easily, especially when you see the language that is used at present. So I don't think that objection really holds water. That's not to say that there is not some need for changes. We can perhaps get into that. But in terms of a wholesale rewriting of the law pertaining to tacit relocation, I just don't think that the case is necessarily there for that. Thank you.
Thank you. Dr. Skilling.
On this point, I would say that my opinions largely align with those of Dr. Brown, but I would add a few additional observations, one of which just struck me about the point about the addition of modernising language, plain English, against the desire to keep particular Old Scots terms of art that have been developed over historical precedent. There are obviously cases in the law of leasing generally where words have fallen out of disuse, and we have been perfectly happy with that. The biggest one that I would say would be the downfall of the word tack, which historically would have been used to refer to the contract of lease, but has now largely fallen into disrepair. Ish, on the other hand, for example, has enjoyed a relatively healthy life to the point that it still appears in the extended meaning of a tenancy definition in, for example, the Private Housing Tenancies Scotland Act of 2016. If this would be a tenancy, but for the fact that it does not specify an ish, it is still regarded as giving rise to a tenancy. There are cases where we are happy to maintain existing terminology while still improving accessibility. And accessibility, I think, is one of the largest themes that comes across in the discussion around this particular bill. The Scottish Law Commission and several of the respondents to this consultation seem to have taken the view, I think in some cases quite rightly, that tacit relocation is a central pillar of the Scottish law of leasing. It's one that's existed for a while, but there is now a perception that for some particular classes of user, it has fallen slightly into obscurity. The biggest ones I am thinking of here are, as the Faculty of Advocates point out, party litigants, persons who are appearing to defend commercial leasing disputes in court who may not have resources of their own. As Dr. Brown observed, there is a very large spectrum of parties to commercial leasing disputes. There are the larger ones, but there is also a sizable contingent of them that are small business owners, franchisees, for example, and just persons who operate their own tiny little bricks and mortar premises and don't have anything else beyond that. There are definitely persons who would benefit from clarification of the law of tacit relocation, perhaps even codification of the principles of tacit relocation in a more easily accessible format. But there is discussion to be had about whether the correct way to do that is to partition tacit relocation into both the common law concept, which applies to some classes of lease, combined with the statutory concept of automatic continuation, which applies to a second tranche of leases, combined, of course, with the third tranche, which is contracts of lease to which neither of these principles would ever have applied.
If I can follow up just from that in terms of the point about the contractual nature of a lease in general and the relation of this to tacit relocation. I note that although it there is in the latest edition of McAllister on Leases, edited by Lorna Richardson and Craig Anderson. I mentioned that it's unclear, for instance, if one can, or there have been doubts in the commentaries, rather, whether someone can contract out of tacit relocation. That doubt appears to have been raised by the SLC report of 2018 itself, and Anderson and Richardson are quite clear, as McAllister was as well, that because of the nature of party autonomy, you can expressly contract out of the law pertaining to tacit relocation. And the whole purpose of this area is quite well described as it stands by my colleague at Strathclyde, Simon Halliday, in an article in the Juridical from about 25 or so years ago. Fundamentally, tacit relocation is a presumption which applies under a limited number of situations where common custom and usage has shown that contractual relations are desired to continue beyond this particular end date. And so, from the law as it stands, if you do have a situation in which the parties to the contract of lease do feel very strongly that actually the date of issue is the date that the lease should end, this can be done. The presumption can be overturned. And that's just something that is worth noting. At the moment, the system that we have is quite flexible. The system that we have allows for party autonomy. And I think that the concerns that making the law rigid and putting it on this kind of statutory basis could be in and of itself problematic. And just because I'm pretentious and can't help myself, I would note that Cicero actually observes this as well. In De Officiis 1.33, a proliferation of statutes only leads to a proliferation of injustice. Having this broken off into its own thing under a distinct regime can be problematic in a way that might not be foreseen at this stage.
Okay. Thank you. So, one of the things that, one of the questions I posed last week was just regarding the bill and whether the bill, if it were to pass, would actually help economically. And so with the codification that's proposed in the bill, so with what you both said this morning, my understanding is that, well, first of all, you don't think codification is the right thing to do, but do you think the bill would actually assist businesses in entering and also leaving leases?
I don't necessarily think so. No, I think that my answer can be summed up roundly as a no, but I wouldn't claim to have any particular expertise on that point. I don't think that this would, if anything, it might make things a bit more difficult, certainly in the short term, and although that might generate some new litigation, which, you know, lawyers pay taxes too, fundamentally, I don't think that this would have any particular economic benefit.
There is also something to be said here about the existing wording of Section 28 of the bill, under which a tenant in certain circumstances has a right to withhold rent when particularly small formal requirements around the provision of a UK address are not complied with. This may be seen as perhaps too extreme a remedy for what is in a lot of cases an administrative oversight rather than a deliberate act of malice on the part of a commercial landlord, and in that sense it actually does have some consequential possible economic downgrade potential as opposed to upgrade potential, but I am also not an economist and would reserve better judgment on that.
Okay, so just before I bring in Ros McCall, judging by what you've said so far, we are going to get into the details of the bill, but judging by what you've said so far, would your recommendation be that the bill is withdrawn or substantially amended? Dr. Brown.
I think that my own preference would likely be to see it substantially amended, and the emphasis there would be on substantially. I think when we have this opportunity to actually reform the law and make changes which are perceived to be necessary, that has to be taken. But I think that a less ambitious bill would better serve the ends of justice in that regard.
Similarly, I don't believe that this is a good time to once again consign commercial leases to the doldrums of a lack of statutory discussion or intervention, but further discussion around the bill would be useful.
Okay, well, thank you very much. Ross McCall.
Thank you, Convener, and good morning. Thank you very much for coming along. That's very interesting, actually. I'm going to start on the first part of the bill, and we'll sort of narrow down a little bit. So you've given us your opinion on that. So what are your views on the first part of the bill, which defines the leases to which the legislation will apply? I'd be interested to know that. And will we go the other way around this time? Dr. Skilling, I'd like you to go first.
So in terms of, for example, the exclusions, in my original response to the consultation which I authored on behalf of the Centre for Scots Law at the University of Aberdeen, we were generally of the view that the list of exceptions makes sense when coupled with the schedule with further exemptions. There were a few little things I did bring up. I think the biggest one, and it was a very minor point, but it was on the lack of an exception for charity accommodation for veterans under part of the Private Housing Tenancy Scotland Act of 2016, which from the wording of it appears to me to be, unlike its sister provision in the same section of Schedule 1 of the 2016 Act, not a temporary housing measure, but maybe a more long-term charity-based housing for veterans scenario where it is more likely than not that that is a person's principal home. The other big exclusion, I think, was residential leases where the residence is not the tenant's principal home. For example, where a person travels for work and has alternative accommodation in place that is not, say, hotel accommodation. There has been case law in the past that has established that a person's main family residence may still be held as their principal home, thus denying them the protections of a residential tenancy, even where they spend the majority of their time in another piece of accommodation, simply because that is the area to which they have the biggest ties. So broadly, I would say the exclusions make sense, but there do seem to be a few either oversights or things that need a bit more looking into to ensure that everything that is excluded is what is really intended to be excluded.
Helpful, thank you. Dr. Brown?
Likewise, I think if this bill is going to go forward, then the approach that's taken here is a sensible one of setting out exclusions rather than trying to capture everything in any other kind of way, other than the observation that was picked up by the colleague who submitted alongside me, Mr. Coombe, as to repairing tenancies and the fact that they are not really likely to actually come into existence. I don't have any observations other than what Dr. Skilling has already indicated.
That's very interesting. So part of the submissions that came in highlighted issues regarding rural areas. What are your views of the arguments that the definitions need to be tightened in relation to grazing, mowing, that sort of rural concern? Do you have any views on that?
I will say that my main specialty is more residential and agricultural, more of an urban rather than a rural, so I will defer on this one.
Okay, thank you.
In terms of this, I would just bring in again the fact that one sees that the kind of approach that is taken in general to having hived off siloed areas of law pertaining to leases does cause problems for exactly this sort of purpose, where having, as I believe the representative for the Faculty of Advocates, Mr. Colquhoun, indicated, having a general law pertaining to leases which is based on principles rather than on individualised statutory and fragmented piecemeal statutory enactments tends to be a bit more useful precisely because of this sort of thing. So that would be my observation there.
Thank you. Last week we heard in the session that there needs to be some consideration regarding electronic communications code, for example, in relation to wind farms and electrical substations. So again, that's another deviation. Again, just to get your views on that Dr. Skilling, please.
On this one as well.
Again, same.
I think my answer is similar to what I just said, which is that if, and this might touch on some of the provisions around notice and the like, which I do note is something of a change from what the law is settled as since 2021 with the Rockford Trilogy case. The general point I would say is that legislating for particular modes of communication is almost certainly doomed to failure, because you are at that point prescribing ways and means of doing things in an area where communication technology is evolving all the time. I think that the law as it stands is quite clear on this, in the sense that because we're dealing with an area that is regulated by the principles of contract, the parties do have considerable autonomy in terms of how they communicate with one another. There's a great line from an Edinburgh Law Review piece from 2004 by the inimitable Professor Gretton, who observes that you can conclude contracts via skywriting if you really feel so minded. So I think trying to bring in provisions to prescribe how communication is to be conducted is wrong-headed.
Very interesting. Thank you very much indeed. Thank you, Convener.
Okay, thank you. And Bill Kidd.
Thank you very much, and thank you to both of you for being here and giving us background on the issues. Now, in terms of your view of the arguments made that there is too much ambiguity in drafting the new statutory code, especially in sections 2 to 7 of the bill, do you think that, for example, section 5(1)bi should be amended so that the term reasonable period is actually replaced with a number of days, for example, 30 days, because reasonable period can lead to ambiguity, obviously. So would you prefer that it was more straightforward?
It may be useful to have 2 periods depending, again, on the length of the lease. One of the bigger difficulties, I think, with the term reasonable in this case is in a lot of situations the bill will distinguish between short-term leases that may be for as little as a month as contrasted with the longer term. Obviously, what is considered reasonable in both of these circumstances is going to be very different. They're working on very different timescales and will often involve very different relationships between the landlord and the tenant. I think in that case, the most useful thing would be to codify it as a hard number of days, but to differentiate between short and long-term commercial leases.
I take a rather different view there, I think, on the basis, again, of the importance of party autonomy where it comes to this sort of thing. What appears, especially at the stage of drafting, to be ambiguous, I think in practice is more likely to be understood as being flexible and accounting for, exactly as Dr. Skilling indicates, the different situations which one can find oneself in this regard. So where that is concerned, I think that keeping this language of reasonable is actually quite useful and more reflective of the law as it stands at the moment. So again, if this is to be a codification that is preserving the best of the law as it stands at the moment, I think that aspect that says, well, instead of saying you've entered into a 6-month lease, therefore 7 days, 14 days, whatever, is reasonable whether you like it or not, recognising that the situations that we can't imagine at this table coming up means that this language of reasonable is a good bit more useful than it might initially appear.
The other potential third option, of course, would be to provide fixed day limits but allow the parties to contract out of those or to modify them, which would represent a middle ground between these two options,
Okay, well,
preserving more contractual freedom.
No, that's it's good to see you sort of agreeing, sort of.
Aggressively agreeing.
But from what you've been saying there, do you think the new rules on giving notice might be difficult to follow due to potential complexity? And do you think that complexity runs through the new proposals overall?
One of the other things I would bring up here is the situation in which oral notice is possible in particular circumstances by the tenant. This seems to me to be perhaps a floodgate of litigation, considering what does and does not constitute oral dealings that would require subjective interpretation of how the parties interacted with each other, the hearing of evidence, and more complexity than an issue such as the giving of notice should require. It should be a relatively simplistic question of whether or not notice has been given or not, and I think there is the potential for complication, especially with that area.
I'd agree with that again, and I think that in terms of this, it would go back to one of the first points I raised about the fact that where you have a commercial landlord-tenant relationship, that does not necessarily mean that the landlord is in a stronger position than the tenant in all cases. As we'll get to the Tenancy of Shops Act of 1949 later, I'm sure, we see that whatever the aims of that legislation may have been, it does tend to be large organisations who are benefiting from that in the position of tenant rather than landlords having this. So in terms of this, I think that rigidifying the requirements to give notice are wrong-headed. I think they go against what the law is at the moment. As I say, I think the law is quite clear, and certainly since the Rockville Trilogy case of 2021, it's quite settled. And again, prescribing ways in which the parties must communicate in order to achieve certain ends seems to me to run counter to the principles of party autonomy, but also does seem exactly like it will be the hotbed of litigation, where parties intend to do certain things, but there's a technical or a minor issue that snowballs into litigation, which could readily be avoided.
I can understand that. It's just, I think that, pardon me, amongst the issues are complexity, as you were saying there, and issues of overcomplication. Do you think that these can be written out before we actually reach the stage of this being passed through as legislation, with negotiation and discussion?
The possibility does exist.
It's possible. I think it's possible, but I think that, again, what you might end up with is a piece of legislation which, if it is really a codification of the common law as it stands, would not appear to be a very ordinary piece of legislation which is trying to do a certain thing. But that's exactly what a codification should be. A codification shouldn't really look like an ordinary piece of legislation. There should be flexibility based into it. So is it possible? Yes. Is it likely that the draftsman will want to go down that road? Perhaps not. But I definitely think it's possible. It's just a question then of the tolerance that parliamentarians have for language that, as you indicated earlier, might be immediately perceived as ambiguous, which in fact is doing a lot more than preserving what the law already is at the moment.
Okay. So, well, thank you very much. Thank you, Convener.
Thank you. Before I bring in Ros McCall, so we are hearing from the Federation of Small Businesses later. Certainly in their evidence to the committee, they do state that we welcome the measures contained in the bill which seek to address some of the power imbalances between small tenants and large landlords, also with regards to this particular aspect. Do you agree with them with regards to what's in the bill? Or do you think the bill in this section as well should have that kind of more flexible approach? Dr. Scully.
I'll come to Dr. Brown on this one first.
I think I can see why, especially if you're a group with interests to protect, that lobbying for those interests is a logical thing to do there. But I don't think that if you're going to legislate in an area that is as broad, complex, relates with so many areas of law as it stands, relates with so many aspects of private law, private life, public life, commercial life, and so on, you can't privilege the interests of one group over another in that way, because although that might be good to the particular case, that can lead to significant injustice in other unlike cases. So while you might be able to redress some of the imbalances that small businesses have when dealing with large commercial landlords, that opens the door to, well, what if you have a small firm that is letting out commercial property and a big titan of retail or the like as the tenant. The imbalance goes completely the other way there, and so I think that needs to be borne in mind when you're dealing with an area of law such as this.
Fundamentally, we are dealing with a long-standing concept of Scots law, which, as an enshrined principle, should, broadly speaking, have neutral application across the broad spectrum of commercial leasing. If additional protections are envisaged, for example, for small businesses, the more appropriate route to deal with that, in my mind, would be something in terms of more boutique legislation rather than the more general principles discussed in this bill.
Exactly that. Because what you're dealing with when you're dealing with common law concepts like tacit relocation is the development of law without political interest really being taken into account. Now, you can make the argument that all law is essentially political, but when the area of law has developed as tacit relocation has over a period of 700-800 years, if not more, then there really is an argument that you're not dealing with political law that favours one party over the other. You're dealing with the best interpretation of justice generally to all that is available. And so, albeit that is the case, there is, as Dr Skilling indicates, absolutely nothing to say that if a particular perceived problem, if the Small Business Federation has particular complaints to raise, that individualised acts could not be passed to deal with that, or individualised legislation.
I'd say that we are not dealing, for example, here with a piece of social legislation. Professor Rennie, in his Sully tome on leases, comments that the battle between residential landlord and tenant is more or less an economic power struggle trying to balance the interests of the two parties over time. But all of the developments in this sector of law have come from a large look over time at how the relationship between these two parties with very specific needs and interests have changed. In the commercial leasing world, in the world of contract, the number of potential interests at play may be wider and more varied.
Yeah, and just because, again, I am pretentious and can't help myself, I'm at a Scottish Parliament committee giving evidence. I can't get away from that without quoting the great Lord Stair. Viscount Stair in his Institutions of the Law of Scotland, very beautiful language, indicates that the nations are more happy whose laws have been entered into by long custom, wrung out from their debates on particular cases, until it came to the consuetude of fixed and known custom. I think deviating from that through passing individual legislation that seeks to codify what's already there but sneak changes in is not a good way of doing things.
Okay, no, thank you. So just one final question before I move on to Roz. So the information that we have received from it was the Faculty of Advocates and also Pinsent Masons. They argued that it didn't make sense to have a statutory code for one type of lease, given that there are rules in case law which apply to various areas of law, not just commercial leases. But bearing in mind, when the bill in front of us is actually a very narrow bill, so clearly it's not broad, it doesn't cover many aspects of leases. So to have, with what's proposed in the bill, for something that is actually very narrow, could that work? And is it practical? Or would you kind of go with the position offered by the Faculty of Advocates and also Pinsent Masons?
This is essentially a targeted replacement in a very narrow sector of leases of a general principle with something which the argument here is more tailored to the sector and is better suited to the needs of that sector. And I can certainly see the strength of that argument. The question then becomes what, if anything, is lost from that general concept when disapplying parts of it or turning it into something that is slightly different.
I think I'm more or less in complete agreement with Mr Colquhoun's evidence when he indicated that if you're going to significantly change an area of law that is hived off from the general law, in a small jurisdiction like Scotland, that is going to cause more problems than it solves, because as it stands, the law relating to tacit relocation is generally well understood. And that means that whenever a dispute arises, there is quite a well-known body of law that can be referred to resolve that. A note, for instance, in the this case just does not stay in my head, the Rockville Trilogy case of 2021, the Inner House dealt with the law on tacit relocation, a judgment of 8 pages essentially, and it was agreed what the law was. It's that well settled, really. It was just the application that was ambiguous. So my point would be that when you're dealing with an area like this, if you're going to have bespoke legislation that does things differently from the general law, it's exactly as Mr Colquhoun indicates. You entrench this new system which, even if disputes are arising, they're not necessarily going to be proceeding to the Court of Session or the Inner House, almost certainly not the UK Supreme Court. And so what you end up with is a new system which is much less clear than what came before, because the law has been unsettled by the legislative intervention. And more than that, until you get a dispute on that particular point, any ambiguities in the law are not going to be resolved. And so in terms of this, although this is held out in part as a codification, it is exactly as you say, it is much more restricted than just that. And so, again, in terms of the suggested redrafting of the bill, I would say that the key thing that I would say is necessary here is for the bill to change as little as possible from the common law, essentially to, as I say, preserve the best of what's in it, and not differ from what is already there, so that you can allow for individuals who need to find out about it. Again, this is redraft the name, please. You know, Lacey's tacit relocation bill would be my suggestion, because if a commercial tenant or commercial landlord searches for tacit relocation, then very quickly they'll be able to find what they need, access it really quite readily. And crucially, if the understanding is that the Act is not actually going to change what the law is before, this means that everyone is able to look to the material that we already have and ensure that even although there is now this bespoke piece of legislation, it isn't actually a bespoke piece of legislation that is going to require a fresh reinterpretation or interpretation. It is just a continuation, an automatic continuation, one might say, of what's come before.
Okay, thank you very much. Ros McCall.
Thank you, Convener. Yes, gentlemen, this has been very interesting because we've had call for views to try and create a parity. So that idea that notice should be the same for both tenants and landlords. But the feeling I'm getting from you is that that parity might actually cause a split, because it's... So could you give me your opinion on... I don't want to put words in your mouth, but if you could give your opinion on that, it would be quite interesting. Whoever wants to go first, I'm not going to choose this time. I'll let you go.
Yeah. Well, again, I think that the issue just comes back to party autonomy, really. That this is an area in which what you're dealing with is custom. If anything, anything that provides greater flexibility is, I think, what we should be striving for in this area.
Similar, I think. One of the other things I would point out at this stage is this seems like a good time to talk about, for example, provisions dealing with multiple landlords or multiple tenants under the same commercial lease, because this is an area where, for example, there is more flexibility in allowing one of multiple tenants to leave a commercial lease but leaving the others in place, which does create some disparity in deciding how to deal with that with notice requirements and all of these things. These are things that I think require to be scrutinised closely in order to ensure even parity.
Yeah, that's very interesting. So does the same sort of thing apply when it comes to tenants being allowed to give give an oral notice? Should there be parity there, or again, are we still looking at that flexibility?
I think here you've got something of a conflict between the need for the preservation of some kind of audit trail as combined with the need for flexibility in this sort of area. On balance, I can see policy arguments for both, that the preservation of an audit trail is extremely important, but of course the ability of the parties, being that a lease is a private arrangement, to do as they will with it is important too. Because this is, I think, I would say that this is probably one of the most small p political parts of the bill, where it's a question of policy. I would offer that view and go no further than that and say that it's a question of expediency. What policy is to be preferred?
Okay, thank you.
Yes, on the one hand, I can see oral notice by tenants working in situations where the landlord and tenant have good relationships, where that later degrades that as a problem. The other thing I'm thinking of here is leases involving family businesses, where perhaps an older generation may lease premises to the younger generation, they later fall out, and these sorts of things cataclysming into long-running litigation, which may cause additional problems.
Okay, that's great. Thank you. Thank you, Convener.
Okay, thank you. And Jeremy Balfour.
Good morning, Convener, and good morning. Thank you for coming. My apologies. I was in another committee trying to make law unsuccessfully. But thank you for coming along. I wonder if we could move on to section 28. And what is your position on the criticism that this allows tenants without withhold payment if a landlord fails to notify them of a UK address? So this is those that have different addresses.
Well, the note that I have in section 28, subsection 3, does just read, "This does seem a bit much," which I think echoes the view that has been taken by some, that a lot of the time the mistake that here results in the ability to withhold rent is, in many cases, a relatively minor mistake as opposed to an act of deliberate malice on the part of landlords. There are plenty of examples across the leasing spectrum of cases where a tenant is entitled to withhold rent because of actions by the landlord with severe consequences, for example, a failure to maintain repairing obligations. But this does not seem to be on the same scale as errors, mistakes, or in some cases negligence of that kind.
Yeah, again, I would say that in terms of the right of retention or the like, that is again something that is born of the fact that a lease is a contractual arrangement, and so where you have a breach of a contract, the general principle that flows from that should be that any damages that you're claiming should be tied to the loss that you've suffered as a result. So exactly as Dr. Skilling indicates, if a landlord is not meeting their repairing obligation, then the tenant is obviously going to suffer some kind of loss as a result of that. Withholding rent payment seems logical in the situation. Here, this is an administrative failure and envisaging an administrative failure, and so I don't see what sort of loss the tenant is actually suffering that would justify them retaining payment.
There may also here be situations where under the current form oral notice may be given without penalty, but written notice, which arguably should be preferred for leaving a greater evidence trail, is penalised because of a comparatively minor mistake.
Okay, that's helpful. Appreciate that. If we can move on to section 30, subsection 3 of the bill. Again, we've had some criticism because it says landlords to serve an irritancy notice to a tenant's creditor. And I wonder just what is your position on whether section 30, subsection 3 does actually work both for landlords and tenants?
The scenario, I think, that was brought up by a lot of responses to the consultation is the scenario where the landlord is unaware that there is a heritable creditor and the effect that that has on the use of the redundancy provisions. There may be situations where it is beneficial for a tenant to withhold information about a creditor, either because they don't perceive it being a major long-running issue going forward, or because they don't want it to be connected to the lease in some way.
Mm-hmm. Yeah, I think that when we're dealing with the nature of the transactions that we're dealing with here, I don't think that there is grounds for intervening so as to actively attempt to guard the interests of one party vis-à-vis the other or the like. So I wouldn't really have anything much more to add to that.
Okay, that's helpful. Again, thank you. Just moving on to finally for me, what is your view of the argument made that the transitional provisions of a bill could lead to uncertainty? And do they need to be altered, removed, strengthened?
I think that it's probably worth repeating once again that given that a lease is principally a contract and the parties to that sort of agreement will have entered into it with certain expectations, and we have to functionally presume that the parties are aware of the law as it stands. Anything that purports to change the law and have any sort of retrospective effect in this area, I think, is a very, very bad idea. And in terms of the transitional provisions themselves, I think that yes, any change in the law is going to generate uncertainty, and so particularly where you've got provisions such as these, litigation perhaps isn't inevitable, but a degree of uncertainty and negotiation will be unavoidable.
This does also seem like a scenario where worked examples would be particularly helpful for understanding how these provisions work.
Okay, again, thank you for that. I wonder, if I can just ask one further question, which should be coming back in later. And if you've covered this previously before I arrive, my apologies. But we heard from a faculty of advocates last week, as you probably read, and ultimately I think their view was that this bill shouldn't proceed to be made into legislation, that we should go back and rethink again. That wasn't necessarily the view of the Law Society or of those in practice. I'm just wondering, from an academic perspective, should, in your view, we proceed with this bill, or are you of the view that it should go away and think again?
We've answered that in that kind of hybrid fashion, really, which is that, and I don't mean to speak for you, please correct me if I'm wrong in terms of your assessment, but I think we're both of a view that reform is something which is worth doing if it's going to be done well, but as it stands, this particular bill, think again is generally the position that would say.
The general position in academia is try not to create divisions where divisions shouldn't exist. There are many things we're very happy to argue with each other about, but the creation of unnecessary arguments is one that should be avoided.
And if I could just push you slightly on that then. So, Judge, I'm not quite sure what you're saying there. Are you arguing, with lots of amendments at stage 2 and 3, this bill could be made to work? Or are you saying the bill is so flawed that even with all these amendments, it wouldn't be good law and we should actually vote the bill down and go away and think again? Can you just clarify that for me, please?
My opinion would be if we are able to hold the mirror up to the existing provisions of tacit relocation and simply restate them and make it absolutely clear that these apply in a commercial context, that this would be the way to go, rather than playing judicial spot the difference between two similar but legally different concepts.
Yes, so essentially then I don't think that we need to go so far as saying throw it out. If this is what it's going to be, then yes, throw it out, vote it down. But it is possible for this bill to be reworked into something which is consistent with the position that we have at the moment, that is going to allow for the principles that exist and have existed for hundreds of years to be stated quite clearly in a place that is easy to find. And so it's worth doing that. but doing that will involve a significant rethink of what is in front of us.
What this bill really does for me is bring up the common theme in leasing legislation in particular, which is highlighting the educational gap between particular stakeholders in the sector. You see this in residential, you see this in commercial with small businesses, as opposed to, for example, responses received from the National Farmers Union and from Gillespie McAndrew, who highlight that among certain sectors, the law of tacit relocation is certainly well known. Obviously, both of us could talk about tacit relocation for hours, but we represent very specific subclasses of people. It's the narrowing of that educational gap, I think, which is the biggest problem in understanding modern 21st century leasing.
I will leave it there. Thank you, Convener.
Yeah. I certainly think that the phrase that was used earlier on by the two panellists was substantial change in terms of the bill. Yeah. So, okay, thank you. Ross McCall.
Coming back in on a pet of mine, which is the Tenancy of Scotland Act, and the view that it should be repealed and the bill amended to implement it. I would be really interested to know what you think.
I think, and I don't at all speak for Mr Coombe here, we jointly submitted and when we did, we were kind of like, oh, well, maybe it needs its own attention. I wouldn't presume to think that his views have changed as mine have, but I think that my views are now quite different from what they were as I've been thinking about it, because I have an observation to make, which is that the last time that the Scottish Law Commission produced a report that did not include a draft bill was, I believe, in 2001 on the report on diligence, and even there they reaffirmed their commitment to, insofar as possible, including a draft bill with any report that they produce. So I think it's really worth observing that when they produced the report on the Tenancy of Shops Act, the Scottish Law Commission, which is committed to codification, is committed to the production of draft bills, looked at this and instead of saying, OK, here's a draft bill to solve the problem, concluded, no, let's just get rid of this. So I think that's a highly significant observation, and it does lead me to the view that a lot of the difficulties in this area have been caused by legislative intervention rather than the common law. So in terms of that, and in recognition again of the fact that world's different from 1949, 1964. The mischief that the Act was designed to remedy isn't necessarily there anymore, provided that it is made sufficiently clear and promulgated that this is going on. I don't see any issue with repealing this piece of legislation, and in terms of reworking this particular bill, although it might be a bit odd to have a provision in there to deal with this. While we've got the legislative opportunity, I don't see any difficulty with that.
This is also the view that I have taken. I'm of two minds that are secretly one mind. Both of them are in favour of the repeal of the Tenancy of Shops Scotland Act 1949 for mostly the reasons stated by Dr Brown, but I also don't want the repeal of it to come with a lacuna in the discussion of what, if anything, should replace it.
That's very interesting. Thank you. Yeah, I have no more questions. Thank you, Convener.
Okay, thank you. And Bill Kidd.
Thank you very much. Right. If we think about an awareness campaign, because there's, from what you've said yourselves and from what we've uncovered, this is going to affect an awful lot of people who are unaware as it stands at the moment. Maybe some of them should be, but there'll be a lot who just don't have any legal background whatsoever and won't be aware of the outcomes of what's being talked about. So do you think, it sounds like a strange thing to say, but the Scottish Government should be carrying out, or coming up to carrying out, an awareness-raising campaign to ensure that the impact of the bill is fully understood on the number of many affected people? Do you think that an awareness campaign should be conducted, and how would you think that would be best put forward?
Yes, Absolutely. I think an awareness campaign is a good thing to have in these circumstances. Leasing especially benefits from them simply because a lot of the time it's viewed as a relationship, but it's not viewed as a legal relationship until something goes wrong.
Yeah, I completely agree, but I would say that my view on that goes, if anything, slightly further. I think that a awareness campaign, even if this bill goes nowhere, I think an awareness campaign is something that would be incredibly useful, because it's exactly as Dr. Skilling says, people do go through life entering into legal transactions every single day without thinking that that's what they're doing. One of the key points in terms of teaching the law of voluntary obligations that I always reiterate is I point at people who have got like a can of Coke in front of them, or the like, not to tell them off because they're not meant to be drinking that in a lecture hall, but to say, well, if you've bought that today, you've entered into a contract. That is a legally binding relationship. And so in terms of that, whether the bill is brought in, whether it's not, whether it's substantially reworked, whether it's not, an awareness campaign is absolutely necessary. I think there are many areas where there is a perception that the law is not working, which, you know, the law is actually fine. The issue is that people don't know what it is. And so what sort of form could that take? That's a very good question. I know, for instance, that for a good many years, in terms of continuing professional development seminars, Professors Gretton and Reid at Edinburgh have offered their conveyancing roadshow to solicitors and the like. I think the universities have a part to play in this. I think that if academics were to engage in outreach, not merely to practitioners of law, but if people like Dr. Skilling and myself were speaking to tenants, landlords, that sort of thing, that could be incredibly useful. And as with many things, the issue comes down to money. Someone's got to pay for that sort of thing. So if there were any kind of appetite for an awareness-raising campaign that would extend to financial support, I think that, yeah, absolutely, the skills to do it are there, I would say.
I think one of the most important audiences, especially here, are persons who are thinking of starting a business for the first time. Small businesses, yes, but it mustn't be overlooked that there are many people who would want to start a business and go to organisations. Business Gateway, for example, that operates in Aberdeen, is one of the biggest ones that I can think of, that providing some kind of educational framework through organisations, working with organisations such as these, giving people this toolkit from the beginning of starting their business career, starting to think about leasing of premises. If it is installed at a foundational level, it will be of far greater effectiveness.
Yeah. So again, that comes back to a drum that I never stop beating, and that is that they need to look at these things holistically. This sort of awareness-raising campaign could absolutely be integrated into other means of supporting small business owners and those who are thinking of becoming small business owners.
This also goes to interdisciplinary work in universities, especially talking to our business schools.
Yeah, absolutely.
So the awareness campaign then, should there be such a thing, and we obviously both believe that there should, the awareness campaign could actually rightly lead to having an educational input in these things, which really is missing at the moment, actually, never mind going ahead to the future here, but it's actually missing at the moment anyway with the existing circumstance with people starting businesses and also those who are dealing with people starting businesses, you know, like those who own land and property and stuff like that. Yeah, okay, thank you. Thank you.
Okay, just as a follow-up to Bill Kidd's question, Dr. Brown, you said a few moments ago, and I did kind of jot this down, but also the official report will give me the full wording. It was along the lines of perception that the law isn't working. The law is fine, but some people don't know what it actually is. Do you have any indication as to kind of what level that is in terms of the perception, but also how many practitioners don't actually know of what the law actually is.
Yep. To clarify that, I don't mean that legal practitioners don't know what the law is. My assessment would be that legal practitioners absolutely do know what the law is, and if they don't, that's a problem for the Law Society of Scotland to take up with them, because they're not competent to be doing the job. So legal practitioners, I think, do very clearly understand what the law on tacit relocation is. When I was saying about a perception that the law isn't working, that isn't a perception that I think is coming from the profession, who broadly say, no, we know what this is, this works quite well. The perception that it's not working is more likely, I think, to come from those who are not lawyers, because if they're not lawyers, then obviously the law is a skilled profession. It does involve special knowledge, and if you're not trained in that, then you don't have that knowledge. And so in terms of this, when I'm saying that there's a perception that the law is not understood, what I have in mind there is very much your business owners who don't have access to legal advice, because if they had access to legal advice, if they sought and obtained access to legal advice, then there wouldn't be this sort of issue. But as we well know, not every business that enters into a contract of lease will have sought legal advice in the construction of that contract.
This again goes back to the point we raised earlier about the increasing number of party litigants before court disputes in Scotland. When I'm not teaching at Aberdeen, my other hat is the legal journalism hat. I write the case reports for Scottish Legal News, and it is becoming increasingly frequent that cases pass across my desk where, generally speaking, the claimant is represented by themselves rather than by legal representation. The need for people outside the legal profession to gain an increased knowledge of legal rights becomes more pressing with each passing year.
Okay, well, that's helpful, thank you. Do you have any further comments about the bill that you'd like to put on the record, or any arguments which have been made in responses to the committee's call for views during last week's evidence session?
The last thing I have written down here is a point about echoing the submissions made in clarification of how all of this applies to unincorporated associations and trusts in addition to bodies corporate, but I'll leave it at that.
I'll just take the opportunity to reiterate again that if this is to go forward, the language of tacit relocation and ish should be retained for the reasons that I highlighted at the beginning.
Okay, thank you very much. Colleagues, have any final questions? No. Okay. Okay, so with that, I want to thank you both for the evidence this morning. It certainly has been very thought-provoking and also certainly very interesting, so thank you very much. So with that, I will briefly suspend the meeting to allow witnesses to change over, and we'll have a 5-minute comfort break. Okay, thank you very much. For our second panel today, can I welcome Alan Cook, the Chair of the Commercial Real Estate Committee of the Scottish Property Federation, and Stacey Dingwall, the Head of Policy and External Affairs, Scotland, Federation of Small Businesses Scotland. Welcome to you both to the committee. And certainly, just to make you aware, please, you don't have to switch on the button for the microphone, that will be done for you. And if you do want to come in on any of the questions, please just raise your hand or indicate to the clerks. But also, you don't have to answer every question if you don't feel as if it's something for you. I'll start off the questions. And do you think that the law on tacit relocation needs reforming? And if so, can you give some examples of practical problems for landlords and tenants caused by the current law? Stacey.
Oh, yes. Thank you for inviting me along to speak to the committee today. So in developing our response to the written submission to the call for views on the bill, we spoke to quite a few of our small business members, and I think overall, we represent tens of thousands of small businesses across Scotland, so we're never going to get complete agreement on any topic, to be honest, not least commercial leases. But I think on balance, yes, there was an acknowledgement that the bill was trying to modernise some of the legislation around this, and this was welcomed by small businesses.
Okay, thank you. Alan?
Yep, I would say similarly with the membership of the Scottish Property Federation, the bill generally has been welcomed, the idea that there'd be modernisation of the law. I guess from a couple of perspectives. Firstly, the general idea that codification, we do actually support the idea that you're bringing it all into one place rather than at the moment having various bits of legislation. If you need case law to understand it, then is that the best position to be in? And also modernisation of some of the aspects of the law to bring it more in line with sort of the way that modern business and society works. So things like changing the notice period from 40 days, for example, to sort of something more representative of how modern business would work. In those couple of different respects, we sort of support the idea of the bill and the modernisation behind it.
Okay, thank you. So you heard the evidence session this morning from the two academics, and certainly from their perspective, that they feel as if the bill were to proceed, it would require substantial change. And also, I think the elements of it where they felt as if the bill wasn't clear. In terms of the two of yourselves, do you think that the bill itself is clear as it's currently drafted, or do you think the bill does need substantial change, as that we heard this morning? Alan.
We're broadly content with the bill as it stands. We regard, I think the intention behind the bill is not to have some fundamental root and branch reform of the approach to how tacit relocation / automatic continuation of leases works. It's about just evolving it, yes, codifying it, but I think if you tried to take the approach of targeting specific aspects of the law of tacit relocation and using the opportunity of a bill just to make those sort of specific changes, then all you're going to do is add yet another overlay to an existing set of rules which has got a number of overlays to it. I don't think that's going to help in terms of making the law clear. We're also supportive of the idea actually that terminology is updated to something more kind of modern language. I happen to be a solicitor. I'm here on behalf of the SPF, but I've got great respect for the sort of traditions and the sort of terminology of Scots law. But the kind of Scottish Property Federation that represents, generally speaking, investors in property, owners, the landlord aspect of things. We want to see a set of rules which are clear and understood, and we think that this the purposes behind this bill are a good step towards achieving that. So we're sort of supportive of that.
Okay, thank you. Stacey.
Yes, I would agree with a lot of that. I think the main thing for us is that the bill, it seems to be seeking to make it clearer and a fairer process for small businesses or people entering into leases. You know, when we speak to our members, you know, they often tell us, and I think this was touched on in the previous session, you know, when the mix of things that they have to do when taking on premises, there's, you know, they're thinking about, you know, everything they need to fit out those premises, getting customers. They maybe don't spend as much time as they should on the legal aspect of understanding what they're signing up to, and they don't have, you know, the means to engage a lawyer. As we probably all know, kind of setting up your own small business in premises is an expensive process. That would just be another expense for that small business owner. So anything that can help small businesses think that they're entering into, you know, they've got a better understanding of what they're entering into. In 2018, the Scottish Law Commission's discussion paper around this legislation noted that while many other countries around the world recognise the concept of tacit relocation, most do so on the basis of positive action of a party, whereas currently Scots law operates through an act of omission. So we think it would be good to address the fact that, you know, small business owners are getting into, you know, they might, when they're negotiating the lease, to be like, there could be an automatic rollover at the end of this lease, or we can set the notice period. So we think it's good that there is that discussion rather than, you know, just a quick signing of a lease. There's more of a discussion and understanding and what's, in terms of what small businesses are getting themselves into.
Okay, thank you. Do you believe that there's a power imbalance between the landlord and tenants, or alternatively large or small businesses? And if so, do the provisions in the bill actually address this issue? Stacey.
Yes, it's certainly our experience that that power balance remains. You know, it exists in situations like this. We've, you know, recent years we've seen small businesses taking on energy contract with the rising energy prices. You know, their ability to negotiate their energy contracts is pretty much the same as a domestic consumer, and it's the exact same in this situation as well. You know, Consumer Scotland, when it was brought in through the Consumer Scotland Act 2020, they have a specific remit to look at small businesses as well as the individual consumer. So I think that's reflective of the situation that small businesses find themselves in terms of the lack of bargaining power that they have when taking on a tenancy.
Okay, thank you. Alan?
I would agree that there can be an imbalance between the interests of landlords and tenants, equally as between, as you say, big businesses and small businesses. That imbalance can be in different respects and in all different circumstances. And what I mean by that is, so for example, you know, there could well be cases where the tenant holds the balance of power over the landlord. You know, we're all aware of the challenges with high streets where there's lots of empty units, for example. Well, if you're the landlord in a high street that's got a lot of empty units and the tenant comes along looking to take a lease, then the tenant is the one who's got the whip hand in negotiation, for example. So equally, you might be a small, you know, an individual who happens to own some property that you want to lease out. And if you've got a national retailer who's extremely powerful and well represented, then, you know, they've got, you know, you're going to be really keen to get them as a tenant. So you're much, again, there's a power imbalance there. So I don't think it's the case that, you know, it's always the landlord who has the whip hand against the tenant. And, you know, in that regard, you know, we're looking for a sort of balanced approach. We think that the bill, you know, provides or offers a balanced approach, and that's certainly what we are looking for. Neither party should be enabled to have the ability to sort of have a whip hand over the other through the regime that we have.
Okay, thank you. And so certainly the general approach to the bill has clearly generated a fair amount of discussion. Obviously, you heard the evidence session this morning, and also we had the session last week. But do you think that the general approach to reform in the bill is the right one for landlords and tenants? Or would you, for example, consider that abolishing tacit relocation be more appropriate? Alan?
The approach of the bill is not to have a huge revolution in the approach to this, and we're supportive of that. if you completely abolish tacit relocation, then I think you're going to all you're going to do is lead to lots of examples of uncertainty, because it's very often the case that parties, particularly I do agree, probably regularly more tenants, but also landlords are not aware of what the law is. But it's also the case that when a lease is coming to an end, sometimes the parties will act in a more acquiescent manner, and the whole point about tacit relocation is it recognises the fact that it might be you might suit the parties, both parties, for the lease to roll on, even though the contractual period of the lease has come to an end. So having the law recognise that that's something which can happen is why the law of tacit relocation exists. And our view would be that you do still need a regime that allows for that pattern of activity to be recognised legally. From a tenant's perspective, they don't want to find that they suddenly and unexpectedly are at risk of being ejected from the premises that they think that they're continuing to trade from. From a landlord's perspective, they want to know that they can continue to recover rent in an orderly manner when the tenant is continuing to trade from the premises. So I think it's appropriate for there to be a regime that recognises the idea of automatic continuation of leases.
Thank you. And Stacey.
No, we wouldn't support the total abolition of tacit relocation. Rather, we would like to see it made mandatory that when the lease has been agreed, that there has to be something there that says what happens at the end date, whether people are happy to opt into an automatic rollover, or whether they want to specify a specific notice period. We would leave that open because there are certainly in some situations, I think as Alan said there, that automatic continuation is desirable for both parties.
So certainly in the FSB Scotland submission, obviously this is something you have touched upon. So would you want that to be made mandatory with regards to what happens when you get to the end date, or would it be some other type of language but which is not mandatory?
Yeah, no, we would like to see it made mandatory. There's an agreement what happens at the end of the initial lease period.
Okay, thank you. And what impact will the proposed reforms have on the economy and businesses in general? I mean, obviously, certainly we've had SLC bills before. Kind of one of the key elements of them has been about trying to help update law and make those specific parts of law better in terms of economic opportunity. And so, obviously, in terms of yourselves, I mean, that's what you do for Scotland's economy, so thank you very much for that. But in terms of the bill, do you think the bill will actually help?
I would hope it would offer some more stability for small businesses. It's certainly the case, in kind of worst case scenarios that we've heard of small businesses being given kind of days notice to vacate premises. And, particularly for businesses that are licence-based, where it takes quite a long time to move to another premises and get licence for the new premises. Given a very short notice period might mean that they just decide not to move to new premises altogether and simply decide to wind up the business. So, if there is a fair and clear process and a specified notice period, I would hope that would mean there would be less risk of that business going under as a result of having to vacate their current premises.
Yeah, thank you. Alan?
I would generally agree with that. As I said before, the intention, as I understand it, of the bill is not to sort of totally revolutionise the approach here. It's a law reform, a law updating process rather than some sort of upending of the way that the sort of relationship between landlords and tenants works. But I agree that changing, for example, the notice period from 40 days. I don't think 40 days, the general view is that that's not really long enough for businesses, both landlords and tenants, to be able to react to what should be happening at the end of the lease. So extending that period is something that I think is a positive thing. It's sort of reflective of the more complex nature of business, both from landlords and tenants. I would add that one of the things that we said in our submission is that there should be more flexibility as to the length of the notice period, to give parties the ability to vary the period from 3 months if it was felt to be appropriate. An example of that, Stacey said, you have tenants and businesses, for example, where they've got licences, like pharmacies is a good example that's given, where they require other licences to be able to trade from those premises, and they need to be able to organise themselves. So the ability of the parties, when the lease is being written, to recognise that and to specify that longer notice periods have to be given will be helpful from an economic perspective.
Okay, no, thank you very much. Ross McCall.
Thank you, Convener. Good morning. Thank you very much. What's your views on Part 1 of the bill, which defines the leases to which the legislation will apply? Stacey.
In terms of...
It sections out where it would be applied. Just wondering if you had any views on that.
I didn't think we had any views on that in a written submission. No, sorry.
That's fine. Thank you. Alan?
Just that generally we agree with the way that that's approached. I seem to recall that the Scottish Law Commission, this bill and the study on the law of tacit relocation came out of a much wider study on how leases might terminate, and this is just one part of that. And there was a lot of there was disagreement among the different sectors of the economy about what the right approach to that should be. For example, agricultural leases have got an established, some totally different kettle of fish from something that's a lease of a high street retail unit. So we support the idea that to allow the law to be updated in respect of regular commercial premises, that we sort of we leave things like agricultural leases and residential leases alone. They've got their own regimes and totally different drivers behind them. So we're sort of focusing here on a sector that can be sort of ring-fenced, if you like, from those other ones with their own sensitivities.
Okay, so would you say, Alan, that would apply equally when it comes to electronic communication codes, things like electric substations, that sort of thing? Would you see that similarly as the rural concerns, or should that apply? Yeah,
I mean, I saw some reference to the electronic communications code, the telecoms leases. Our membership doesn't have a sort of specific view on that, other than that a note, and I can see the point that some people are making in that those leases have got their own regime, and that the notice to quit process is a sort of an additional overlay on that. In respect of other leases such as substations or energy leases, I would say that what those the parties to those leases would be able to do is to, going forward, leaving aside the way the transitional arrangements might work, would be to agree what their own arrangements would be by the ability of the Act would give them, the Bill gives them, to contract in or to contract out, or, as we have proposed, to have the flexibility to adjust the notice periods. With that flexibility being given to people, we don't necessarily feel that there needs to be a sort of, particularly extended set of carve-outs.
That's interesting. Stacey, I don't want to force you to answer if it's not in the field, but just to give you the chance to answer that question, if you just the other side of it when it comes to substations, I don't know if that would be something that you'd be speaking about from your membership point of view, but.
No, sorry, unfortunately,
that's
not something that's come up.
I didn't want to not give you the opportunity to answer the question if you wanted to. That's me, Convener. Thank you.
Okay, no problem, thank you. And Bill Kidd.
Thank you both very much for being here. And can I ask, in terms of views on arguments made that there is too much ambiguity in the drafting of the new statutory code of the bill, do you think that say Section 5 should be amended so that the term reasonable period is replaced with a number of days for exactly 30 days? I asked this question of our previous panel also. Do you think the term reasonable period is something that's too open to different interpretation, ambiguity and such like, and it should be more specific? Do you think that matters at all? Anyway, Alan?
Yeah, we do have some I guess, concerns on that section of the bill, that there is some uncertainty in there, both in respect of the reference to reasonable period and also the reference to whether or not the landlord has taken steps to remove the tenant from the subjects within a reasonable period. It does seem to us to be a bit unclear as to just what you would be able to do or not do to sort of meet that test. So as far as reasonable period is concerned, we're not proposing, we don't have a hard alternative proposal to make that is what would suit our membership, other than to say that we would agree that something that's a bit more definite would be helpful, more guidance in the legislation, whether there's a sort of baseline that you can then sort of move away from in a particular situation, but some more guidance would be helpful. And also in the same regard, the reference to not taking reasonable steps to remove the tenant. We said in our submission that more guidance on that would be helpful. For example, does that mean that you have to launch court action? Does it mean that writing a letter is enough, or that doing something more than just being completely silent is enough? Some more guidance on that would be helpful, because we can see the scope for argument and dispute arising from that.
Okay, thank you. Stacey?
Yeah, definitely. I guess, what are the parameters of a reasonable period? Your and our understanding could be very well different of a reasonable period. I think when speaking to our members about this bit of legislation in the Tenancy of Shops Act, they were very clear that an absolute minimum 3 months notice period is what they would require, what they would see as reasonable. And just when Alan touched on court action, I should say that court action was the absolute worst thing that small businesses could see having to enter into. Some of them said it would be absolutely catastrophic for their business if court action was something that they had to engage in. So in terms of the specific section of the bill, I think it would be important, well, maybe if we didn't specify 30 days, as you said, I think we would need to establish parameters of what a reasonable period would be.
Oh, thank you, because that actually, it's useful what you mentioned there, actually, because we're wondering if about the new rules and giving notice can sometimes be difficult for people. Now, I would imagine that Scottish Property Federation and FSB members can be guided towards reasonable or decent legal advice, but there will be those who don't have access to that. And do you think that that the new rules would be more difficult for them to be able to follow than the present rules, or the same?
I don't see it as being any more difficult, in the sense that I think it's correct to recognise that there's a whole swathe of landlords and tenants who do not ordinarily take legal advice or are aware of what the law is, and a lot of them are not, particularly tenants, are not represented when small leases are entered into. So we, as a sort of landlord representative body, we're very aware of that. The sort of landlords are not here to sort of try and sort of exploit people. But if you're not aware of the current law on tacit relocation, then it's just as likely that you're not going to be aware of the law on automatic continuation of leases. And yes, you can have education campaigns, but it's only going to ever take you so far. So I think that's why it's important for the law to have default arrangements which apply, which are reasonable, balanced approaches in circumstances where people don't realise that there are things that they could or couldn't be doing as the lease is coming to an end. And the law on tacit relocation, as I said before, that's kind of why that law exists, to give a kind of default which is seen as a sort of fair, balanced thing to do when people don't realise that there are things that they might otherwise positively do. I think the bill takes a similar approach. So I don't see the bill as really disturbing that in that regard. I don't think it's going to sort of make much difference. It's not going to, in itself, it's not going to educate people.
Right. Well, just on that basis then, without causing any contentious disagreement between yourselves, which we're not trying to do. Do you have views on any of the arguments made that the rules on giving notice should be the same for both tenants and landlords, which is in contrast to the approach taken by the bill? Should both sides, if I can put it that way, have to have the same rules as each other and just work with those? Which might make it easier for people to understand, actually.
Yeah, certainly we do. And I should say FSB, so as broad as our membership is, we obviously represent small landlords as well, so we're probably not on completely opposing sides on that side. Yes, no, this is something that we looked at as part of our submission. So it's our understanding that as currently drafted, Section 3 of the bill prevents parties from having the flexibility of negotiating for a clause where the landlord would be required to provide a longer notice period than the tenant. You know, in practicality, it may be the case that the scenarios in which this would be negotiated would be few and far between, but on balance, given that, you know, our understanding that the bill is geared towards providing greater protection for tenants, is our recommendation that the legislation is amended to offer this flexibility and therefore protection for small business owners. We're aware of the situation in England and Wales, where if the parties have not contracted out of the Landlord and Tenant Act 1954, the requirement is that the landlord must give 6 months' notice of whether they oppose renewal expiry, and the tenant 3 months' notice on whether they wish to renew. So, given that that's the situation in England, where there's the ability to have different notice periods, we would support the same situation in Scotland.
Thank you. Alan?
Yeah, broadly similar view. I think that the bill at the moment is a bit rigid in the notice that's to be given by either party. We're supportive of more flexibility on that. We are also recognisant of the fact that perhaps the preponderance of power balances in favour of the landlord. I think I've said that that's by not any means always the case, but you know, what we suggested in our submission is that there should be more flexibility where the parties could adjust agree in the contract, the lease, that there would be different notice periods that would apply. But we're content to propose that the landlord's notice period could never be made to be shorter than the tenant's one. So, sorry, the other way around. So the tenant doesn't have to give less notice than the landlord. You know, we're content with that. The tenants need to understand where they stand, but there would still be adequate notice being given on both sides.
Well, thanks. In terms of where there's a lease of term of less than a year, what do you think about of tenants being able to give oral notice? This has been challenged to some degree by the legal profession that says it could create evidential difficulties should there be disagreements and so on. But do you think that oral decision, oral notice would be sufficient, or would you think that written notice really should be the direction to go?
Yeah, I think it would be reasonable to expect at minimum, you know, an email, not, you know, handwritten notice. I think an email would suffice over oral notice. And
that's not determined by the length of the lease. That would just be whether it was 1 year or 10 years or something.
Yeah, I just think it's good practice just for everyone's, you know, certainty and understanding that there is something documented in writing.
Okay, yeah. And Alan, you okay with
that?
Yeah,
we're a similar view. We're not comfortable with the idea that notice could be oral where it's a shorter lease. You know, you could imagine a scenario where there was a conversation between landlord and taking place where the tenant says, perhaps in a sort of fairly informal sort of way, oh, my intention is to leave. And then the conversation moves on. Well, is that something that the landlord should be treating as notice of intention to leave or not, or was it just a conversation that was just taking place? And there's the grounds for the dispute. So we're sort of not comfortable with the uncertainty that it creates.
Okay, well that's very helpful. Thank you both very much. Thank you.
Okay, thank you. And Jeremy Balfour.
Thank you, Commissioner, and good morning. Thank you very much for coming along and your evidence this morning. I'm going to follow similar questions I gave to the first panel, and again, if you don't have a view on it, then absolutely fine. But I wonder what is your position, if you have any, on the criticism made in response to the call for use of Section 28 of the Bill, which would allow tenants to withhold payment if the landlord fails to notify them of their UK address. Alan, I think maybe one for you to start with.
Yep. We don't. We think that it's disproportionate to the situation that's at hand. It's recognised that if a landlord is not in the UK, then it's very helpful for there to be an address in the UK that can be used for notices, of course. But the bill does say, it does still give some guidance to the tenant as to what they would do in terms of serving a notice. Ultimately, they can serve a notice to the court instead. Now, if you're a landlord and you haven't complied with the requirement to provide an address of service in the UK, then sort of hell mend you. If the risk that you're running is that you don't find out what it is that the tenant is saying is to happen at the end of the lease, that is a big risk for you to run. And we would argue that that risk in itself is a sufficient sort of stick, if you like, to beat the landlord with, rather than this additional move of withholding rent, which we don't think is appropriate. I think it's disproportionate.
Anything to add, Stacey?
No, I would just say that it's not just in terms of being able to give notice to a landlord. Not being able to get hold of a landlord can be a common issue for small businesses. Not just in terms of exiting the tenancy. So I think that's why, to go back to my earlier point of having that agreement up front as to what will happen at the end of the initial lease period is also important with that respect.
Okay, thank you both. What's your position on the criticism, again, in response to the core views of Section 30, subsection 3 of the Bill, which requires landlords to serve irritancy notices to a tenant's heritable creditor? Alan, I don't know if you want...
Yeah, I don't think we have a particular concern with it. It doesn't feel to me to be that much different from the reality of how most leases work these days, where if the lease is a long lease where the tenant is able to grant a standard security over its lease interest, and there's therefore a creditor that might be in place, it's quite normal for there to be provisions in the lease anyway which require that notice. Landlords are, I think, really quite comfortable with the fact that that's the scenario, and if you're serving a notice, then you go through some careful steps to make sure, if you're a solicitor, and a landlord, you take some careful steps to make sure that the notice that you're serving is the correct notice. And part of those steps would winkle out the fact that there was a standard security over the tenant's interest, that there was therefore somebody to whom notice needed to be given. And from the perspective of the bank or the security holder themselves, it's appropriate that they should be aware of what's happening to the lease, which is the asset over which they hold security. So I don't think we've got a particular concern with that approach.
Just to follow that, because the law says it's got to go for a step further. They say that the tenant has to give notice to the landlord if there is a heritable security over the property. Do you agree with that position of the Law Society?
From the landlord perspective, it's certainly helpful to get that notice, because if you don't get the notice, there are still ways that you could find it out. You could do a search in the registers of Scotland, and that's doing a search in the registers of Scotland is a step that a prudent landlord and their solicitors would undertake before they served notices, so they knew that they were serving it to the right people. But to have the awareness and for the tenant to be sort of notifying the fact that security has been granted, I think is certainly a helpful thing from a landlord's perspective.
Okay. Anything to add, Stacey?
No views on that.
Okay, thank you. And then finally, from me, I'd like to hear, what is your view of the arguments again made about the transitional provisions that it will lead to uncertainty for partners in at least this kind of transition period. Do you have any views on that?
We don't. Our members didn't have a particular sort of settled view on the transitional arrangements. I'm kind of in two minds about it myself. On the one hand, that what the rolling over existing leases into the new regime so that the new regime applies to them is a sort of, in some ways, might be seen as a cleaner approach. If you take the view that the law is ultimately, not a revolution, and that it's not seeking to completely alter the arrangements between landlords and tenants in a sort of economic and commercial sense. On the other hand, I can also see the point that a lease is a contract which has been framed between the parties in the context of the law as it was understood at the time. And if you impose some new laws on that arrangement which hadn't previously applied, then the parties haven't had the opportunity to take that into account. So we don't have a sort of settled position on that, other than to agree that it's not a straightforward question. That's probably not a very helpful view.
No. All views are helpful. Stacey?
No, it's not something that we've discussed with our members.
Perfect. Thank you, Camilla.
Thank you. Can I just go back to Jeremy's first question regarding the UK address? Does it matter if it's actually an agent on behalf of the business and the landlord? Are you content with that?
Yeah, I think that's pretty common practice in terms of it being an agent. Just a point of contact is helpful.
Yeah. Alan?
Yeah, I would agree with that. I mean, almost by definition, if the landlord is somebody who's outside the UK, then the person who's going to be the address in the UK is going to be somebody on their behalf and not them. So it's perhaps seems to me sort of that it's almost always going to be an agent of some sort.
But kind of going back to one of Stacey's points earlier, where you did indicate that there are occasions where the small business owners find it difficult to engage and talk to the landlord. So in this particular aspect of the bill, would this be problematic if it actually were an agent in contrast to the landlord, or doesn't really matter?
No, I mean, I would, I guess, my understanding would be that the agent would have the right to, make commitments and negotiate on behalf of the landlord. So I don't see that being an issue.
Okay, thank you.
I would just, if I can just add to that, there's a distinction between being able to have negotiation and conversation with somebody who's outside the UK, which you could still do, and having somewhere where you can serve notices on them for legal purposes in the UK. And I think it's the latter that the Act is talking about, or the bill is talking about. But it doesn't change the fact that you may still have a phone number, for example, or an email address that might not be the correct medium for serving notices, but it's still a line of communication, so there is still that potential.
Okay, no, that's it. Well, thank you. And Ross McCall.
Thank you, Convener. Yes, back to me. The Tenancy of Shops Scotland Act. I think this is probably something that might fall a bit more within your wheelhouse rather than my other questions. So, does your organisation have any experience of how the rules of that works in practice? Who wants to go first?
Yes.
Stacey,
yes. So, yes, we engaged with our members around about the discussion paper that the Scottish Law Commission brought forward last summer now. And also we were grateful that the Scottish Law Commission hosted a round table with our members to kind of discuss that with them. So that's where a lot of those comments around, small businesses saying it would be catastrophic for to have to engage in kind of court action and those kind of things. And it's where our arguments around the notice period originated as well, with there kind of being a consensus. I think a lot of people were pushing for a 6-month minimum notice period, to be honest, which I think, as we've discussed, is probably required for certain types of licence-bearing businesses, but I think on balance we kind of settled on that 3 months. we have been quite reticent about repealing the Act altogether without having something in place to deal with any of the issues that it might leave behind, because I think there's maybe a thinking in some parts that, you know, we've completely dealt with some of the issues we might have had in the past in terms of that power imbalance between landlords and tenants, and I think, as I've said, we are still finding those issues. So we are quite reticent about that being repealed completely without something else as a kind of backstop for that.
Okay, thank you. Alan, I'll come back to you, Stacey, if that's all right, but Alan, could I have your opinion on that?
Yeah, so we had similar engagement with the Scottish Law Commission on their proposals on the Tenancy of Shops Act. We support the idea that it's repealed, and we support the idea that that's brought into this bill. The Tenancy of Shops Act is not well known about and recognised. But I would say, certainly in the landlord community, I don't want to put words in Stacey's mouth, that may be the wrong thing to say, but I would argue also in the tenant community and the retailer community are not really aware of it. Now, if you ask somebody, if you tell somebody that they have it, that they have this mechanism, and do they want it to be removed, they're probably going to say no. But if they didn't know about it in the first place, then, and from a landlord perspective, it's you know, there's been very little. Very few instances where it's ended up in court, for example. I would say that from a landlord perspective, it tends to be used more by well-represented national retailer tenants as a negotiating chip against their landlord, rather than something that's actually protecting the rights of shop owners, shop retailers, and the kind of mischief that it was designed towards. I think it was earlier this morning said this, and I agree with that, that the kind of mischief that it was designed for just after the war isn't really as relevant now, and we think that it's the right time just for it to be abolished, and for the same regime to apply to shops as to anybody else.
Okay, thank you, Alan. I'm going to come back, Stacey, if I may, because you're talking about that imbalance that you see that is still there. Mm-hmm. You know, the Act was there primarily used by larger businesses, is the assumption, larger supermarkets, for example, rather than smaller shops. Is the intention working, do you think, from the Act? And what are those imbalances that you're seeing, if you give me an idea of that?
Yeah, definitely. I think Alan is definitely right. You know, we don't have scores of our members coming to us and say we know our rights under the Tenancy of Shops Act. You know, that's certainly not happening. And I think what, you know, obviously this was last summer, and now we've had this piece of legislation come forward. You know, if that does take care of some of those issues around, you know, the minimum notice period and making it mandatory to agree what happens at the end of the initial lease period, I think that kind of addresses some of our concerns with repealing of the Tenancy of Shops Act. I think it's absolutely right. You know, people have called it the mischief that the original Act was brought in to address. It's no longer as widespread, but yeah, I think you're right. We are still seeing some incidences of that mischief.
Okay, so thank you for that. So you've both given me your opinion as to whether you think it should be repealed or not. Do you think there has been enough consultation? If we're going to repeal and then sort of slip this into the bill and the legislation we're looking at, has there been enough engagement? Has there been enough understanding, etc.? Are we in the right place for that decision to really be made? Stacey, again with yourself.
Yeah, I think it's difficult because in this kind of thing we find it, you know, quite challenging to engage our members in it. You know, it's kind of, you know, hopefully in most of the situations you're talking about hypothetical situations. You know, what would happen if this happened, and you know, particularly at this in our current times, our members are very busy trying to just get on with, you know, keeping the doors open and, you know, hoping that they still have doors to open. But you know, so trying to engage them in something that's quite technical and legal is very challenging, to be honest. So there's certainly been, as I said, we had that session with the Scottish Law Commission. We've certainly tried to speak to our members with regards to this call for views. So there have definitely been many efforts. I'm content with the attempts to engage with our members.
Okay, thank you. And just sort of last question, Stacey. If we did go down the route of repealing it and sort of pushing it through in this legislation, what are the issues that you think would come from that? Because you've stated that you would really not like it to be repealed. So What kind of issues do you think would come? Or obviously, it would, that's a how long is a piece of string question because you don't know what's in it. But you know, is there any issues that you can foresee?
You know, I think, as I said, in terms of the repealing, I would probably be a bit softer on not repealing it because of this bit of legislation. So that, as I said, that's kind of addressing some of the concerns that we had. Yeah, in terms of what potential issues, I guess, you know, would it potentially, at the worst case scenario, make some landlords withdraw from offering premises to small businesses and then they kind of have to move out? I guess anything that risks the stability of small businesses, you know, further kind of endangers that relationship with the landlord. Because, yeah, you know, I do talk about some, you know, cases where landlords have been unscrupulous, but we know there are equally as many members who have a great relationship with their landlord, and indeed we represent some of those landlords, as I said. So I certainly wouldn't want to be tarring landlords with the same brush.
Okay, thank you. Alan, I was very much focusing on Stacey there. Is there anything else you wish to add on that point?
Just to add that in terms of kind of bringing this proposed measure into this bill at sort of a later stage, if you like, in the sort of process of this bill, the tendency, there's been, you know, a number of years of engagement by the Scottish Law Commission in consultation on what should happen to the Tenancy of Shops Act. So I would see it more that it's a case that the sort of that process has come to its conclusion at a convenient moment that allows it to be brought into this bill, rather than something which has sort of come out of nowhere. I wouldn't look at it that way.
No, I accept that. Thank you very much indeed. Thank you.
Thank you. Before I bring in Bill Kidd, so Stacey, a few moments ago you did say that obviously you're reticent about repealing the Tenancy of Shops Act, but also if it did happen, you need to have some type of backstop to deal with it. You also touched upon, I think, well, in terms of the bill, that kind of goes some way to dealing with that. Are there any other specific things that the FSB Scotland would actually like to see if the repeal were to go ahead, whether it's in this bill or as a separate piece of legislation?
I think it's that kind of notice period, having to be, you know, move away from that 40 days. I think we've all kind of agreed that that's not enough, and yeah, just move towards that kind of positive action in terms of agreeing what happens at the end of initial lease. That's really the key thing for us.
Okay, thank you. And Bill Kidd.
Thank you, Convener. Thank you again. I know you were both here when I asked the two academic witnesses who we had earlier what their views were on arguments in responses to the call for views that the Scottish Government should carry out an awareness-raising campaign. The two doctors were very much of the opinion that this was an educational situation where people really needed to learn about their rights more and be aware of them so that they wouldn't find themselves in difficult circumstances so often, and they'd be prepared for anything which took place which was not necessarily what they were looking for. So on that basis, I don't know, I will ask you, do you think that there should be an awareness-raising campaign of the suggestions and proposals in this legislation in order to make sure that both landlords and tenants have awareness of all the different new aspects which are coming towards them?
Yes, always a fan of disseminating information. I think the main thing to think about is what the right vehicle for that would be. You know, with all due respect, kind of information from government, you know, doesn't land the way with our members as it might coming from ourselves, to be honest. Just in terms of the engagement with that or the understanding, I guess that's kind of a big reason why membership bodies exist, to kind of engage our members in that. I did like the point that one of the previous panellists made around, you know, when you're at Business Gateway, you know, having that kind of package of what you need to know when you're kind of starting up a small business. I think that's a very good point. For us, our position is that kind of awareness campaign of what goes into starting a small business and all the things that you need to be aware of should actually be incorporated into particularly further education, you know, vocational courses. You know, there's kind of a module on this is what it's like to run a small business. These are all the things that you might need to do. join FSB, obviously being one of them. But, you know, just the kind of basic kind of places to go for help, because, you know, I think as someone mentioned previously, if you're part of FSB, then you do have access to a kind of legal helpline. So I guess it's, in terms of an awareness campaign, yes, it'd probably be good to say law has changed. I think a lot of people, unless they were right in the middle of a dispute with their landlord, would probably just ignore it, as I said, to try and just focus on getting on with the day job. But it might kind of plant that seed that if they do run into issues in the future, that there is something there to help them.
So as well as educationally, which is obviously extremely important and people all seem to agree on that, do you think that it could be very, very useful perhaps that the Scottish Government should bring on board the FSB and the Scottish Federation to try and talk through and develop knowledge across those who are most likely to be affected by the legislation?
Yeah, I think there's certainly many examples of that working well in the past, so I would support it here as well.
Yeah, and Alan? Yeah.
Yeah, just really, I kind of agree with everything that's been said. The awareness of the law, but of the impact it has on how a business needs to operate commercially and run its business, including how it should operate when its business leases are coming to an end, for example, or when a landlord's lease is coming to an end. I think we would always want people to know where they stood on that. The bill make some changes, such as, for example, if you happen to be somebody who knows what the law of tacit relocation is, and you think that you've got 40 days notice in your mind, well, the bill would require a longer period. So we wouldn't want people on any side of the table to be tripped up by that. Now, we support the longer period, but there's that transition phase that you need to sort of guide people through. Outreach, I think the best way for outreach to happen is through organisations such as the FSB and other member organisations who've got that direct connection into the people that you're trying to approach. So I think a targeted information campaign would be helpful and would be supported.
Oh, sorry, well, no, but thank you both very much indeed, because that's helpful to have panels 1 and 2 going along the same direction. So thank you very much for that. Thank you.
Okay, thank you. So just finally, are there any other points or comments about the bill that you'd like to put on the record? Obviously, we've heard the hearing session this morning and also the 2 panels we had last week. Are there any particular points or comments you'd like to pick up on from any of those as well? Alan?
I've got nothing else to add. I would commend our written response to you, and nothing else that I wanted to particularly emphasise today.
Okay, thank you.
Perfect, similarly for me, yes.
Okay, thank you. Do colleagues have any final questions?
No, that's excellent. Thank you.
Okay. So thank you very much for your evidence this morning. I think once again it's actually been very helpful and very thought-provoking. So it certainly will help us as we continue our deliberations, and also when we have the Minister in front of us in a couple of weeks' time. So with that, once again, thank you very much. And also, if there are any particular points after today, please, if you can send them to us in writing, that would be helpful. So that now concludes the public part of the meeting, and I'll move the committee into private.